In our business, it has a likelihood of happening often since we have a small community. So you may wind up initially representing a manager who then takes on an artist, and that artist may not have an attorney. So the first way that the bar requires us to address that conflict is full disclosure. You've got to let the new client, in this case the artist, know that you're already representing the manager. They have the right and should seek independent legal counsel. They may say, I don't want to. I like your style and I want you to represent me, in which case you can represent them subject to certain conditions. One, you can't represent them in any legal dealings that they may have with the manager. It's a direct conflict. You can't give both sides conflicting advice as to how to tackle and address a specific contract or an issue that they're on opposite sides of the table on. You also would need to have that waiver in terms of general representation signed so that everybody's real clear that you're representing both parties, but you're not representing both parties for conflicting identical issues or interests. So, the artist may not have an attorney. You were representing the manager, and now you're representing the artist, but you're representing the artist for other deals with other parties, as opposed to things going on between the artist and the manager. Each band member, hypothetically, and from a textbook standpoint, should have independent legal advice before they get into the shareholders or partnership agreement for the band. At the point where they are all one unit, then yes, normally one attorney will represent the entire entity as a cohesive unit because they're just one functioning unit as opposed to 2, 3, 4, 5 different, conflicting interests.